Hello everyone, welcome back to my YouTube channel, Next Gen Lawyers. And today we are discussing one of the most important constitutional law cases in India. Muhammad Hanif Qureshi was a state of Bihar, which is decided in 1958. Okay, now this case was not only about how the cow, slaughters. It was actually about the bigger constitutional questions, like what happened when the fundamental rights come into conflicts with the DPSP. That is Directive State Principles of State Policy. And can the government completely ban our professions in the name of public interest? And the another important question was, can a DPSP override a fundamental right? And does such a ban affects the religious freedoms? So now let's discuss the entire case analysis. So now let's just talk about the bench of this case. Okay, the bench is basically S.R. Das. Let me highlight this. S.R. Das, Justice Imam, and Justice Bhagwatis, Justice A.K. Sharkar, Justice H.N. Bhagwatis, and the court which where the judgment is being delivered is the Supreme Court of India, and the case name is obvious. Muhammad Hanif Qureshi was the state of Bihar. Now let's just talk about the background of the case. In 1950, the several state passes the laws to protect the cattle. And the cow, that is the Bihar, UP, Madhya Pradesh, introduces the certain laws that can, ban the slaughters of a cows. So these laws were made to implement the Article 48, that is the DPSP. So after implementing that, many traders or who was the Muslims felt that these laws were seriously affecting their livelihood because all their livelihood are dependent on this trade like cow slaughter. Therefore, they approaches the Supreme Court under Article 32 that they are being, the laws are being violating their fundamental rights, that is right to trade. So this is the background of the case. Now let's see the facts of the case. So the petitioners belongs mainly to the Qurayshis communities, that is basically just considered it as a Muslim communities, and they're traditionally involved in the meat and the cattle trades. They earn their livelihood by slaughtering the cattle or related animals and sell their meat and other products. And when the state laws completely prohibits the slaughter of a certain cattle, the petitioner argues that these laws are directly violating their fundamental rights, like that is under Article 19, which destroy their businesses and also violates their constitutional rights. Therefore, they challenges the validity of this law and before the Supreme Court of India. Now let's just talk about the parties involved in this case. The first one is petitioners, which involves the Muhammad Hanif Qureshis and the other Qureshis communities. Then the Muslims, butchers, and the cattle traders, and the people who involved in the meat, leathers, or the related businesses. And the respondent is state of Bihar, state of UP, and the state of MP. Now let's talk about the legal issues. What are the legal issues in this case? The first one is whether the complete ban on a cow and the cattle slaughters violates the Article 19, Clause A, Subclause G's of the fundamental rights. That's guarantees the rights to profess any business which is considered to be legal, not illegal. The second one is whether the ban violates the religious freedom, which guarantees under Article 25, and whether the law violates the equality under the Article 14. Now, let's see the arguments of the petitioners. The petitioners argue that their traditional occupations depends on the cattle, cow slaughters, and related businesses, and they said that the complete ban made it impossible for them to earn a livelihood. That's why they also argues that sacrificing the cattle during the Bakra Eid was connected to their religious practice, and therefore they claims that the law violates their Articles 14, Article 19, and Article 25 of the Indian constitutions. They basically argues that all their livelihoods are being dependent upon the this business, that is cow slaughtering, and if the the state is being prohibiting us from slaughtering the cows, it will directly affect their businesses and they cannot earn money or they cannot sustain their livelihood. Now let's see the arguments made by the respondents, which by defending the Article 48, which says that Article 48 guides the various state governments to implement certain policies, certain laws that can protect the cows and the various other cattle. They also argue that the cattle are not just an animals; it basically plays a very essential roles for the agriculture, milk productions, and the rural economy. The government believes that preserving the cattle was a large public interest. Therefore, restrictions was reasonable and it is not unconstitutional, but it is constitutional because it we are protecting the larger public interest. Now let's see what the Supreme Court said about the Article 48 of the Constitutions. Article 48, which comes under the DPSPs, tells or guide the government to take necessary steps to protect the cattle or the cow. The court also observed that these cows are not just and ordinary animals, but it plays a very important role in the agriculture activities in the Indian agricultures. Because of this economy importance, the court agrees that the governments can take a necessary steps to protect such animals. However, the court also says that they cannot override the fundamental rights. In simple words, if I want to say that the governments cannot ignore the constitutional rights while implementing the Article 48, both should be balanced while making the decisions or making the laws and policies. The next issues was the religious, that is Articles 25 of the Indian Constitution. The petitioner, that is the Muslim community, that is Qureshi community, argues that sacrificing a cow on a Bakri Eid was a part of their religious practice, and therefore the ban violates the religious freedoms. And to decide this, the court examines the Islamic teachings, various religious practices, and after studying the matter, the court found that Islam does not make it compulsory to sacrifice the cow specially. The Muslim can sacrifice any other animals or various other animals such as goat, sheep, camels during the Bakrid. Sacrificing a cow is not essential religious practice, and that's why the court held that the law did not violate any fundamental right, that is Article 25 of the Indian Constitution. So, according to the Supreme Court, the ban did not interfere with the fundamental rights to freedom of practice or religion. Now let's just talk about the Article 14 of the Indian Constitutions, where the petitioners argues that the law were very discriminatory and violated Article 14, which guarantees the equality before the law. However, the Supreme Court did not agree with the statement, because the Supreme Court says that the cows and the cattle are very important animals, very essential animals that plays a very important role in agriculture sector. And due to this importance, the governments can create them differently or treat them differently from other animals. And the court said that the classification is valid if it has a very reasonable basis. And since the purposes of the laws is to prevent the kettles, protect the kettles, the classifications was reasonable and constitutional, and therefore the court held that the Article 14 was not violated. Now let's talk about Article 19, which is very important in this issues because it provides a right to carry on a professions or the businesses under this articles. The court accept that the ban can affect directly to the livelihood of these type of people who are carrying the businesses, but also says that the fundamental rights are not absolute. The constitution allows the reasonable restrictions if they are imposed in a public interest, and the court also held that the protecting useful cattle was reasonable restrictions, and because of such contributions to the agriculture's milk and productions, therefore banning their slaughters was justified. But the court also noted or said that the old or unproductive cattle no longer provided these benefits, and according to the court, a complete ban on the slaughters of such animals was unreasonable because it imposed an unnecessary burden on the people involved in the trade. And this is because this is the most important part of the judgment, because the court upheld the ban on useful cattle but stuck down the ban on old and useless cattle. Now let's talk about the judgment of the Supreme Court. After hearing both the side, the Supreme Court tried to balance the interest of the state as well as the fundamental rights of the petitioners by agreeing that the cows are very useful. जो केटल्स है, जो cows है, वो बहुत ज़्यादा important है because it plays a very important role in agriculture sector, क्योंकि वो milk provide करती है, farmers को farming activities में help करती है, and therefore the government can legally prohibit the slaughters of a cow and others animals, other kettles that are very essentials for the milk productions or the agriculture work. बट कोर्ट ये भी ऑब्जर्व करता है कि जो सम एनिमल्स होते हैं, जैसे वो ओल्ड हो जाते हैं, वीक हो जाते हैं और अनप्रोडक्टिव हो जाते हैं, जो कि नो लॉन्गर ज्यादा बेनिफिट प्रोवाइड कर सकते हैं, जैसे कि वो ज्यादा मिल्क प्रोवाइड नहीं कर सकते एंड कैन नॉट परफॉर्म्स द एग्रीकल्चर वर्क. सो द कोर्ट हेल्ड that keeping a complete ban on the slaughters of these old animals also is unreasonable because it automatically or it directly creates a burden on the farmers. कोर्ट ये भी ऑब्जर्व और रिजेक्ट करता है आर्ग्यूमेंट ऑफ द petitioner, जो कि बोलता है कि द लॉज दैट बैन दैट प्रोहिबिशंस ऑफ अ cow slaughterings डायरेक्टली वायलेट्स देयर फंडामेंटल राइट्स ऑफ अ रिलीजियस अंडर आर्टिकल 25. द कोर्ट जजमेंट देने से पहले बहुत सारे मुस्लिम स्क्रिप्चर्स, टेक्स्ट, बहुत ये सब पढ़ता है. उसके बाद दे केम टू द कंक्लूजन्स दैट there was no such compulsory practice in Islam to slaughter the cows in the Bakrid. The Muslim can sacrifice other animals as well, and therefore the law does not violate any fundamental rights to religious practice. The law जो कि state ने जो laws implement किए हैं prohibitions of cow slaughterings, वो कहीं से भी right to religious practice को violate नहीं करता है. कोर्ट ये भी कहता है कि जो डायरेक्टिव प्रिंसिपल्स और स्टेट पॉलिसीज है डीपीएसपी जो आर्टिकल 48 है उसके अंदर, वो बताता है कि स्टेट शुड इंप्लीमेंट सच लॉज एंड पॉलिसीज दैट कैन प्रिवेंट एंड प्रोटेक्ट द काउज फ्रॉम बीइंग स्लॉटर. बट स्टेट को ऐसा लॉज इम्प्लीमेंट करना चाहिए ताकि वो पब्लिक इंटरेस्ट एज वेल एज individuals के rights को violate ना करो and respecting the constitutional rights. Hence, this is the end of the video. I hope you like this video. Please like, share and subscribe to my channel. Thank you.